Great. Welcome, everyone. We're going to give it a minute for folks to join. Great. Do we have Samira on, Hannah?
Not seeing her on yet.
Okay, let's give it 1 minute. And for those of you signing in for CLE, you should have the document is already posted. Oh, there we go. Okay. Great. We've got Samira on. So Samira, are you ready? I will introduce Samira and I'll introduce this topic and we'll head. All right, we are ready to get started. I'm Jen Walling, Executive Director of the Illinois Environmental Council, and this month in June, we've been working on a number of legal series webinars to discuss some current issues. Most of them have focused on energy, and we do have quite a number this week. But I'm really excited about this one, and Samira is going to introduce Kyle Berry. But I met Kyle at the Double Black Diamond opening in for the solar project that is in Sangamon County that's powering Chicago. And Kyle is working with a number of the counties on the siting law. And so we really wanted to learn more about permitting and the process through which counties and companies go through and an evaluation of Illinois siting law and wind and solar permitting. And he is the expert in Illinois on these from that level. And so I'm going to hand it over to Samira to introduce him and read some of his bio. And then we'll head to Kyle. And just a reminder for CLE, you've got the CLE credit document is in the chat. We'll post it a few more times, but you'll need that to get the credit for this. So passing it on to Samira.
Jen. Hi, everyone. Again, my name is Samira Nessian. I'm IEC's Director of Energy Policy, and it's my pleasure to introduce our speaker for the session, Kyle Berry. So Kyle is a partner at McGuireWoods LLP and Senior Vice President of McGuireWoods Consulting. His practice focuses on renewable energy developments, and he counsels wind and solar energy clients on zoning, permitting, tax, and other project development issues in all parts of the state of Illinois. He has assisted clients with renewable energy projects in nearly half of Illinois' 102 counties. As a former attorney for the Illinois Department of Commerce and Economic Opportunity, or DCEO, Kyle also has a strong understanding of economic development incentives and works with clients to identify and negotiate the best available opportunities. He also has extensive training and experience as a commercial litigator. So Kyle received his Bachelor of Arts degree in Political Science and Political Economy from Washington University in St. Louis, summa cum laude, and he received his Juris Doctor degree from the University of Iowa College of Law with honors. So with that, Kyle, I'll turn the mic over to you. Thank you so much for being here.
Thanks, Samira, and thanks, Jen. I'm excited to talk to you today about citing issues associated with wind and solar in Illinois, primarily solar, because that's the hot topic these days. And in particular, I'm excited to talk about the implementation of Illinois' new state siting law. As Samira indicated, just a quick addition to my bio. I was a commercial litigator for 8 to 9 years in Chicago. Moved to Springfield in 2004 to take a job as Deputy General Counsel with DCEO. And it was there that I became interested in energy issues and renewables. I served as the lawyer for the Renewable Energy Division, which included the Renewable Fuels Division. And then I also did some other energy work for the department. When I left, I joined McGuireWoods in 2005 to help open up the office here in Springfield, and which is where I'm coming to you from today. And shortly after I came to McGuireWoods, I co-founded the Illinois Wind Energy Association. And what I mean when I say that is I literally walked over to the Secretary of State's office and using my own money founded a corporation called the Illinois Wind Energy Association, then helped build that with some other folks. As Samira indicated, I've now worked in nearly half of Illinois' counties. Jen mentioned that I saw her at the grand opening for the Double Black Diamond solar project here in Sangamon County, which is the largest solar project, almost 600 megawatts east of the Mississippi currently. And as you can imagine, I've been living and breathing the implementation of the new siting law for the last couple of years. I also want to mention that I try to walk the walk to the extent that I drive around a lot of Illinois, but I drive most of the time in an electric vehicle. It can be challenging at times in certain parts of the state where solar projects are being developed. In particular, Western Illinois doesn't have a lot of charging stations. Southern Illinois has some gaps, so we got to continue to work on the charging networks. But with that, I will go ahead and move forward with my slides. First, I thought it would be good to cover some federal regulations and incentives that apply to renewable energy projects. You usually have to get a permit or some sort of approval from the U.S. Fish and Wildlife Service, the Corps of Engineers, and the FAA. For solar projects, they really don't present impediments. Sometimes the issues are avoiding wetlands, waterways, and FEMA floodplains, but that's about it. The biggest driver right now of renewable development at the federal level is the Inflation Reduction Act's provisions relating to the investment tax credit. So as many of you are probably aware, the current revenue bill, I don't know if that's the right way to call it, in Congress, the big beautiful bill would potentially dramatically reduce the incentives available for wind and solar. So as you might imagine, I've received a lot of questions recently from clients about what can they do to perfect their special use or siting permits and move on to the building permit stage in anticipation that this bill might reduce the incentives before they can take advantage of them. There's still hope because the Senate is yet to weigh in on the bill, and there's at least a discussion among some of the Republican senators that they may not as dramatically reduce the IRA provisions. We'll see what happens though in the next couple of weeks. But if that could have a dramatic impact, at least nationally, on development. So at the state level, there are several incentive opportunities. I thought it would be nice to kind of share what a couple other states do, and I'll address those first. Minnesota provides exempts equipment associated with solar energy production from sales tax. Virginia also provides sales and use tax exemptions, and some real estate tax abatements may be available. But Illinois provides some really good incentives, which, by the way, may be increased if, depending on what happens with the big, beautiful bill, the state may have to step up, unfortunately, and to continue to drive project development opportunities. But wind and solar are both allowed to be designated as high impact businesses, which allows them to receive sales and use tax exemptions on equipment and building materials for renewable projects. There's a real estate tax abatement opportunity that can be tapped into for wind and solar. The big enchilada, though, in Illinois is the incentives that are provided by the Illinois Power Agency's program, which is a continuation of incentives that have been around for a while, but were recently boosted 3 or 4 years ago by the enactment of CEJA, or the Clean, well, I always get the Clean Energy Jobs Act, I believe, is one way it's been described. So a big thing that law did was it created what's called a strike price, or introduced the strike price concept to Illinois Power Agency driven 20-year power purchase agreements that can be obtained via competitive procurements by wind and solar project developers. And that strike price essentially created a REC price that a renewable energy certificate price, excuse me, that's the primary incentive that wind and solar projects can obtain. It's the strike price allows the price of the REC to float, and by doing so, it increases and decreases. It's tied to the market price, and it helps make sure that these projects can be financeable, because those projects that receive a power purchase agreement can go to financing parties or banks and say, hey, I've got a revenue stream for my project. And whereas it used to be the REC price was a number, like let's say $4 or $5, $10 per REC. Again, now it floats. It's tied to the market price, and so it essentially allows the project to receive a competitive price regardless of what the market's doing. If the market price is high, then there may be no REC payment made. If it's low, though, and that's very important for the project's finances, then that difference in the market price and what the project needs to succeed is made up by the REC price. So there's also, for community scale solar projects, those are defined as projects that are 5 megawatts or smaller. The IPA's Illinois Shines program offers long-term agreements as well under adjustable blocks, which have the fixed prices, or at least targets. And but the IPA has in response to some very successful that very successful program has had to adopt a scoring system. And as a result of all the successes that the IPA has had, it's warning about a funding cliff that is potentially going to start in around 2030. And one of the reasons the IPA is concerned is because of those floating REC prices. They can't predict what the market's going to be like in 5 or 10 years, so they don't know how much these power purchase agreements are going to cost. And I apologize for the brief overview of a complicated incentive structure, but that topic's probably could be covered in a separate presentation. But again, it's important to understand that that the IPA's program is one of the big drivers behind wind and solar development state. So the other thing that's been happening for the last 5 years or so with Illinois projects, they've been significantly delayed by what they call the Q reform at the PJM, and that's the it's called the independent system operator, the grid operator for Northern Illinois, including Chicago, and MISO is the grid operator that covers the rest of the state, essentially, or most of the rest of the state. And so the upshot is that I have seen projects die on the vine because they've been waiting for approvals by the grid operators to plug in. And because of these reforms and other delays in studying the interconnection process for projects, projects have literally, that I've had permitted, literally died on the vine, or the economics, the delays associated with the reforms have just caused the economics to go out of whack, and the projects have died. I mean, I think 5 years ago, we permitted a 350 megawatt project in DeKalb County, and it's not on the books anymore. That one's not going to happen. I have other projects downstate that have been waiting for a similar amount of time, 3, 4, 5 years. And again, they're just waiting for feedback or approvals from the grid operators. Meanwhile, as folks probably know, that there's a high demand for electricity, a growing demand of electricity in the state. Part of that is driven by new data centers and other tech facilities that gobble up a lot of electricity. And so we need that new generation to come online, but the grid operators are just not allowing it, and there are probably good reasons for that in some circumstances, but maybe not so good reasons in others. So, and as I indicated on the slide, those delays are undermining the state of Illinois' public policy initiatives, such as the Renewable Portfolio Goals, standard goals, and the Clean Energy Jobs Act's goals. The consequences for permitting are sort of on the ground, and the challenge that the delays has presented is that permits that I helped some of my clients obtain 3 or 4 years ago are set to expire, or have expired, or would have expired, I should say, if we hadn't gone back and asked for extensions. But the extension requests can be fraught with peril because you have to go back before the same permitting jurisdictions, boards, and councils that you've addressed before. And if your project had opposition, that gives the opposition a second bite at the apple. There's also an education issue because we may have significant board turnover in a period of 4 years. Some people decide not to run again. There are some people get knocked out of their positions after an election. So it creates, those delays create challenges, atrophy, and can be a real problem to the extent that they'll end up killing projects, which is not what we want, at least from my standpoint. So, all right. One more background slide. Thought it might be useful or interesting to see how other states do it. In Minnesota, for projects that are over 50 megawatts, it's statewide siting. The Minnesota Public Utilities Commission does the permitting and siting for those projects. For smaller projects, it's done at the local level, either by a municipality or a county. In Wisconsin, it's similar process, except the numbers are 100 megawatts or greater. And for the local siting decisions, they're made for projects that are under 100 megawatts. In Illinois, all the action is at the local level. Many projects, because they're in rural areas, are primarily the siting jurisdiction is the county board. Those county boards can issue special use permits, conditional use permits. After the new siting law, some of them are called siting approval permits, or they may offer no permits if they've decided not to regulate the siting of solar or wind projects. And by the way, that's not true for and the other thing about Illinois is that a CPCN is not required, which is that is a certificate of public need, short version. That would need to be obtained by the Illinois Commerce Commission. Except for transmission facilities, it is required in Illinois and Missouri too. But for wind and solar projects, that's typically not an issue. So again, all the action is at the local level, in counties before the county board, and in front of municipalities, it's the village council and village president or mayor. Quickly want to run through some of the approvals or regulations that come into play for wind and solar at the state level in Illinois. And the Illinois EPA requires a construction permit for stormwater purposes. They also oversee the statewide sound limits, and that's important. I'll talk about that in a little bit. The Illinois Department of Agriculture requires an agriculture impact mitigation agreement. That's a statutory requirement, and it essentially helps protect the land during the project's operations, and then afterwards it requires thoughtful decommissioning and drain tile repair. And drain tile is a very big issue in Illinois. It's essentially a series of pipes that are buried under the soil in much of central Illinois in particular, and they help drain the soil so that farmers can more readily plant crops. State Historic Preservation Office plays a role. They require a consultation. Typically, again, not an issue for solar projects in particular. None of these statewide regulations typically come into play for solar. With the exception of perhaps the Illinois Department of Natural Resources, there's something called the EcoCat review that requires a developer to have the site evaluated for an impact on state threatened and endangered species. Again, because most of these projects are built on farm ground or ground that's already been disturbed, typically not an issue because those species are not around. One potential positive is that the recommendations that come out of DNR that are pretty standard these days are a recommendation that the project follow the Illinois Pollinator Act in terms of the plants that go under plant species that go underneath the panels. And a more recent development is DNR is recommending that the fence not go all the way to the ground, but it should leave a gap of about 6 inches. And that's to allow smaller critters to go back and forth under the fence and into the pollinators under the panels. So let's now talk about Illinois' new siting law. For those of you who aren't familiar with it, it went into effect at the end of January of 2023. Now, one of the things it did was that the first thing that it did is that it added solar facilities to a provision in the Illinois Counties Act that used to be called wind farms. Now it's called commercial solar and wind. And that is significant potentially significant for some other reasons that I'll get into in a little bit. But that was a big change because prior to that, counties, at least that didn't have zoning, were not or arguably not authorized to adopt any regulations for solar. And after this law, they can. The other thing that it did was it required counties to, within 120 days, to adopt ordinances at their local level to conform with the standards in the act. And that's why I thought when Jen and I spoke, when we met at this groundbreaking, I thought this would be a really good time to talk about how the implementation of the siding law is going, because it's been almost 2 years since those most of those ordinances went into effect. I think they had until the end of May, essentially, of 2023 to adopt the ordinances. So we're seeing the after effects now. It's been about 2 years, and it's been interesting how things have played out. The law really established guardrails for county wind and solar siting authorities by limiting the restrictions those counties were allowed to impose on zoning and siting permits. And the law was necessary because there were, I don't know, 5 to 10 counties that were really giving a hard time to folks who were trying to site and build wind and solar projects in the state. And so the law in particular went after those decisions to try to impose moratoria on wind and solar facilities. And in fact, it's expressly prohibits counties from completely eliminating wind and solar. It also limits the scope of setbacks, fees, and other restrictions that counties are allowed to impose on wind and solar permits. The specific language is that the counties cannot impose any zoning standards that are more restrictive than those standards in the Public Act. And again, this was all driven by a small percentage of Illinois' counties. So most of the counties had reasonable or fairly reasonable regulations for wind and solar, but again, there were some that were they really didn't want wind and solar, and that was, I guess, a philosophical thing. Although I find it interesting because it's a tough. It creates a clash between, the local siting philosophies and property rights of the landowners who have typically enjoyed wide range of choice in terms of the activities on their lands in downstate Illinois. So I find it kind of an interesting dichotomy between those, and will occasionally that comes up at hearings. So again, as I mentioned, the counties were prohibited from regulating the siting unless they adopted an ordinance. There are no bans allowed, no moratoria allowed in agricultural districts and industrial zone districts. So, and as you might imagine, since most of the projects are in those two zoning districts, that's really opened up things for counties that were a problem before. And I'll address this on another slide, but the statute says that a solar permit application shall be approved if the applicant demonstrates compliance with the statutes and the county ordinance and other things. The new statute, want to make clear, only applies to counties. The amendment was only to a provision in the county's code. That's particularly significant when it comes to unzoned counties. And I have a slide on that. And that's because of a concept known as extraterritorial zoning jurisdiction, which has been the bane of, which has been created another challenge for some of the developers in certain counties. Again, setback limits were, other than the ban on moratoria, the setback limits were probably the most prominent change in the statute. There were some counties that were that wanted like 2-mile setbacks for wind turbines from homes or non-participating properties. For solar, it was, I think, probably half. Some of them were proposing half-mile setbacks, and the statute said you can't do that anymore. They've adopted for solar 150 feet. For wind, it's more of a ratio. I think it's 2.1 times the height of the wind towers. Other setbacks to public roads for solar and wind. For the height for solar, there's a limit of 20 feet. Because that was another thing that counties were doing. They were limiting the height. Again, they were trying to make them invisible essentially to neighbors. There's the waiver concept allowed in the statute, and I mentioned this earlier. Another problem that had been encountered at the local level was that counties were adopting noise limitations that made it very difficult to site projects. Typically not a problem with solar, but with wind turbines, since they're much taller, can project noise farther. The new siting legislation, however, essentially overrules any local zoning permits, zoning ordinances that relate to sound at the county level. And it says they can't be any more restrictive than the Illinois Pollution Control Board limits. And again, for solar, really, the only thing, solar projects are actually really quiet. The only equipment that generates noise will be the transformer and the inverters, and there's a little humming sound. And if you properly site them in the middle of a solar project, no one should hear them outside the boundaries of the project. And so, the upshot is that the new legislation effectively implemented a statewide sound limit for wind and solar projects at the county level. The act prohibits counties from imposing unreasonable fees for permitting and for other things. The act also limits the decommissioning rules at the county level to those that are imposed in the Agriculture Impact Mitigation Agreement, or AIMA. I mentioned that a few minutes ago. That's an agreement that must be signed by every project with the Illinois Department of Agriculture. And so that's essentially created statewide decommissioning standards. Road use agreements, this is something that has caused delays, at least with projects, and arguably local road authorities have shaken down wind projects in particular, charged extraordinary fees, and the statute addresses that, and it requires the county to tie those fees to actual costs that might be incurred during construction and the impacts on the roads. Otherwise, again, county road authorities were charging what in some instances were just unreasonable fees that they were pulling out of the air. So I mentioned earlier that the statute says that the counties shall approve a siting permit if the developer or the applicant demonstrates that it's met all the standards. So that begs the question about whether the legislature intended to preempt local siting laws with the enactment of the new siting law. And certainly there have been folks who have made that argument. I think the emerging consensus, however, was that there is no at least total preemption of county zoning rules and authority. And I'll give you a couple of reasons why I take that position. Number one is that the language in the law did not expressly state that it was designed to preempt local siting rules, or more importantly, or just as important, that the statute did not overrule court decisions. And there are some important court decisions that come into play when siting permits are challenged at the local court level. So one of those cases was called involved LaSalle County, I believe, and it's commonly referred to LaSalle factors that arose out of that decision. And under that decision, courts are directed to evaluate decisions about the issuance of special use permits using a balancing test applying a number of factors. Some examples are that the proposed use won't impede the development or unreasonably interfere with activities on neighboring properties, the extent to which property values will be diminished by the proposed use, and whether the proposed use will provide for adequate utilities, drainage, ingress and egress, or other necessary facilities. So again, there's no mention of the LaSalle factor or any other court decision in the new siting law. Also, there were statements made during the legislative debates that indicate or suggest there was no preemption because there were a lot of complaints by interests representing the counties that the state law was taking away their siting authority, and the pushback was during the legislative debates that the statute was not. It was merely imposing guardrails. Likewise, Governor Pritzker at the time stated publicly on more than one occasion that the law did not take siting decisions away from counties. So I think on the basis of those things and other things, that there's no, again, this is an emerging consensus, I think, that there is no at least total preemption, but we don't know yet because the statute has only been around for a little over 2 years. But again, since most of those ordinances weren't created until 2 years ago, we're still seeing how they're playing out in practice. And while there have been some lawsuits, I'm not aware that any have made it to the appellate court level yet. So the law is still emerging, which is kind of interesting.
Kyle, do you want to take questions now or at the end? It did see a hand raise, so.
Whatever you prefer.
Yeah, why don't we take them at the end? So I know, Kendall, I see your hand raised. There's a question box if you want to put your question in there, and then we'll take them at the end. So thanks, Kyle.
Yeah, no problem. So then if there's no preemption, what does shall approve mean? And so the statute says that, again, a siting approval request shall be approved if it complies with the following. And this reminds me of my corporation law professor. One of the things he said back in law school, which is, according to him, the first rule of statutory construction is read on. So if you look at the first couple provisions, under following shall be approved, it says if it complies with the standards in the siting law, makes sense. The zoning ordinance that was adopted in conformance with the siting law also makes sense. And conditions imposed by state and federal statutes and regulations. Well, I think that last sort of catch-all is where the consensus is, at least it's emerging, is that refers to the LaSalle and Sinclair oil factors, that the sort of the court-driven common law when it comes to reviewing special use permits and or siting permits. And again, because the act didn't expressly overrule those decisions, it's expected that judges will continue to apply those factors when evaluating decisions about special use and siting permits. Now, I will say that one of the lawyers who represents a number of counties, when he's helped them develop their siting ordinances, and most of those counties that he has advised include some version of the LaSalle factors in the solar siting ordinance. So we'll see what the courts do on this, and it'll be interesting to see how it's developed. But I think for right now, that's the way this is rolling out. And things are, as I mentioned earlier, are kind of fluid. So what have the counties done in response to the new Siting Act? Well, a number of things. Some of the counties have simply decided not to regulate the siting of wind and solar. So essentially, they have elected to treat wind and solar siting permit applications as permitted uses. So no hearing is required. Instead, you just file an application for a building permit, and the county zoning officer reviews it. And if you comply with the standards for a building permit, you get a siting permit. Most counties, however, are not doing that. And if they've elected to regulate the siting of wind and solar, then a public hearing is required. And that's an opportunity for folks to weigh in, and those things can get messy and lengthy. And some of the counties, as you can imagine, some of the counties that were the reason why the statute was developed in the first place have adopted countermeasures. So, for example, 2 or 3 counties have sought to leverage this extraterritorial jurisdiction concept that I mentioned earlier, that municipalities have as what I would argue is an apparent roadblock to solar development. In fact, at one point, a county state's attorney instructed the zoning officer in that county to not accept any solar permit application for projects located within 1.5 miles of a municipal border. I mean, he effectively, for at least a year, created a moratorium in those areas. And again, something the statute clearly prohibits, but they did it nevertheless. 2 other counties require solar projects located within that 1.5 mile, what we refer to as the ETJ, extraterritorial jurisdiction, to enter into a pre-annexation agreement with the municipality. Well, the result in that requirement is that as soon as that pre-annexation agreement is signed, the parcel then is subject to the zoning jurisdiction of that municipality. So again, if you play that out in a county, it can create all kinds of mischief if the county cooperates with the municipalities, and could result in significant areas of the county effectively prohibiting wind and solar, which again is not allowed under the statute. I haven't seen that play out, but this approach raises a number of issues. Again, you could have because counties have county zoning has primacy. It could inadvertently create unzoned areas in the county, which I don't think the authorities want. It only applies to incorporated municipalities. So what do you do in unincorporated ones? And then what happens if a municipality hasn't adopted a zoning code? Why should you be required to enter into a pre-annexation agreement with a municipality that doesn't have zoning? There hasn't been a lot of thought given to this by the local authorities when they've done that. But again, I think it's to a certain extent, it could be a poison pill. Another county has prohibited solar projects where the soil is rated above a certain quality. And the argument is that they need to preserve high quality farmland, high quality soil in that county. But again, the statute says no moratoria in ag zoned territories or ag zoned districts. So I don't see how they're going to get away with it. The county has denied at least a couple projects on that basis, and I believe they've sued. So we're monitoring those lawsuits. Other counties have sought to address issues that aren't covered in the siting law. So in other words, the siting law says you can't adopt an ordinance that's out of conformance with the law. Well, what about issues that aren't addressed in the law? So insurance, for example, there have been counties that have more than quadrupled or significantly increased the levels of insurance that have traditionally been required for solar projects. And in my opinion, they've gone way above market. They've imposed fees associated with building permits that are dramatically higher than what was done before the siting law. And some county ordinances require screening of projects that are located in areas where nobody is going to see them on a regular basis. And I'm just not really sure that makes sense and that's consistent with the theme of the statute. But nevertheless, those provisions are in some of the statutes. I will even say that there's at least one county that has openly defied the state siting law. It adopted a standard for wind turbines setbacks that's basically twice what the siting law allows. So we'll see how that plays out. I mean, they're just going to lose if they get sued. So I'm not sure what the thought process is there. So newsflash to the counties, this just in, counties never had as much choice as they think they did. Why do I say that? Well, because of an Illinois Supreme Court precedent from 2001. Essentially, that precedent essentially says, and I'm arguably taking it too far, or at least the lawyers who oppose wind and solar projects have told me that. But I mean, the language in the case is pretty darn good. It says that when essentially, if a county has adopted an activity as a special use, then a request for that use can't be denied based on the use itself. Instead, it has to be denied because the use is not a good use at that particular location. And this has been the law since 2001. So after the siting law and during the development of the siting law, there were a lot of voices at the local level saying you're taking away our siting authority. But again, the reality is that under this decision in Chicago Heights versus Living Word, they didn't have as much authority as they thought, because a reading of that decision is that counties essentially pre-approved a use like solar in ag districts unless it can be shown that the use at that particular location creates adverse effects that are higher or greater than what would ordinarily be associated with a wind or solar project. So, again, my read of that case is that you can't block a solar project if you've designated it as a special use because it's a solar project. I think, and that's when I do hearings around the state, I hear all kinds of grievances raised about projects as solar projects. That's why they don't want it. We don't want to look at these things. They're monstrosities or whatever. But the reality is that that's not a good reason to deny one, and it hasn't been a good reason since 2001. So while the applicant has always bears the burden of proof that it satisfied the standards, the opponents have to show that that particular use in that particular location will create extraordinary adverse effects that are different from like a normal solar project. And that's hard to do. So I mentioned this earlier. I'll cover this briefly. This has been a problem. Jockeying over jurisdiction is a problem in unzoned counties, in unincorporated areas, because in unzoned counties, municipalities have extraterritorial zoning jurisdiction that extends 1.5 miles behind their boundaries. In zone counties, the county zoning extends all the way to the borders, but not in unzoned counties. So that's a big area. The areas of 1.5 miles outside of corporate boundaries is a big area. And what happens, I'm dealing with a situation right now where two municipalities have overlapping extraterritorial zoning jurisdiction. And the question is, what do you do? Who do you apply for who do you apply to for a permit in those overlapping areas? It's not an easy, there's not an easy answer to that question. And it's causing a delay of the project moving forward. So I see that I want to leave some time for questions, but so I'm running out of time, but I'm excited to talk to you about some real world examples. Um, I don't want to humble brag here, but I had one of the best meetings I had the other day in a tiny town of about 200 people at the kitchen table of a zoning officer for a township in unzoned counties. Townships can create a zoning code. And it was a really useful meeting because I'd only seen one page of their zoning code previously, in part because I think what I learned once I sat at her table, she showed us the zoning code, and it was a stack of loose leaf pages that the page numbers were handwritten on the pages and it was kept in a manila folder, and that was the zoning code, the official zoning code for the township. We had a conversation and walked away with some direction, but prior to that, we were getting conflicting signals. But um, that was, that was a very surprisingly effective meeting in the middle of nowhere, Illinois. So I mentioned this, how do you square the jurisdictional circles when you have the overlapping municipal extraterritorial zoning jurisdiction? I'm still working through the answer to that question. So if anybody has any ideas, let me know. The hidden trap of private drainage districts. I had a situation where a private drainage district killed a project because it wasn't on the map and it wasn't on the county's website. So it was not something that we discovered until the project went for a hearing, and the private drainage district board members used it as a lever to kill the project because their pipes went right through the middle of the project. So I've seen the shield and the sword used by a municipality in one instance effectively to kill a project. They claimed that the comprehensive plan had designs on the host parcel for the project, even though that parcel had sat vacant since 2007, but they still wanted to build housing on it. And so what did they use that as a shield to argue that the board shouldn't approve the project? Meanwhile, they came in last minute with an involuntary annexation attempt, and which they used as a sword because municipalities, under the right circumstances, can involuntarily annex parcels. So that was a surprise, and it was an effective use by a municipality to kill a solar project. Noise issues, I put this on here because there's a dispute, or there can be a dispute about where the noise should be measured under the Pollution Control Board rules. It's not the rules don't focus on zoning, they focus on the actual use. So if you have a residence on an 80-acre parcel, 79 acres of which of that parcel are farmed, where do you determine when the residential use begins and the agricultural use ends? And some noise consultants will measure at the wall of the house. Others will draw a buffer area around the house, but it's not clear where you're supposed to start measuring for noise compliance. And I guess the last one I'll mention is the holding the ball strategy. There is a wind project in a county downstate that has gone through at least 20 nights of hearings, 20 nights. I think that is far too excessive. I think arguably the statute certainly authorizes, the new siting law authorizes counties to not to reduce the repetitiveness of questions, et cetera, and testimony at hearings, but 20 nights is a lot. And while that would probably be good for my business, I hope I never have to go through a 20-night long hearing. And by the way, that issue was addressed in the next slide, the omnibus energy bill that was heavily considered in the spring legislative session, but didn't pass. It was called and then pulled during the last day of the session, kind of ran out of time. I looked up what an omnibus bill, what omnibus means, and it basically means many things, including many items like an omnibus bill. So that bill would have addressed the siting law and helped with a number of issues, it would have imposed a deadline for public hearings. Their length would have limited some of the fees I talked about earlier and put restrictions on vegetative screening. It faced a challenge, and the legislative leaders will continue to work on it over the summer, and we hope that they are able to pass the bill in the fall veto session. But the feedback we received was that there were concerns about rate impacts on ratepayers, particularly in light of increases in power bills that folks are going to see here over the summer that resulted in what was a capacity auction, meaning that there's not enough electricity generation in this part of, at least in downstate Illinois. And the other challenge is that now that the spring legislative session has expired, the vote requirements are higher than a majority. So with that, I will turn things over for questions, Jen and Samira. But I hope you enjoyed that presentation. Happy to answer any questions you might have at this time.
That's really wonderful. Thank you so much, Kyle, for that fabulous presentation. Folks, we just have a couple minutes left, so if you have any questions, please either use the raise your hand function in Zoom or add any questions to the Q&A function. We do have one under Q&A. Kyle, which Illinois rec program is facing a funding cliff? The indexed rec program or the ABP community solar rec program?
I'm not exactly certain, but I think it's all of them. I think it's the overall renewable energy budget that the Illinois Power Agency oversees. There are limits on what that budget can be based on a cap in the Illinois Power Agency Act that can be charged to ratepayers. It's a complicated formula that is a percentage based on what market rates were in 2009, but that cap limits the overall budget that the Illinois Power Agency can deploy on an annual basis. It has rules about how it distributes the funds in that budget, but I think their concern is mostly about the overall budget.
Great. Samira's doing these questions, but I don't see anything else in the chat.
No, I don't either.
You guys got anything else? This was super impactful. Really appreciate it. Anybody last questions before we end? No. Cool. Well, we'll have this recorded and we'll have the slideshow and materials. Oh, Caroline, why don't you go ahead? Oh, I need to let you speak, I think. Allowed to talk. Okay, cool. You're allowed to talk, Caroline.
Cool, and it's Peter. I don't know why I'm coming up as Caroline.
Oh,
That's
pleasant
fine.
surprise.
Yeah, no worries. I guess I'm like a little confused about when counties are doing these sort of illegal things under the like under the new siting bill. Like, what are we as advocates supposed to do in that situation? Are we supposed to tell them that it's illegal and that they should stop doing it? Like, are we supposed to bring a lawsuit? Like, what do you do when they're purely violating the law?
Yeah, that is a great question. And I have clients ask me that question. At the end of the day, at least for my clients, they're interested in building solar projects, right? They're not interested in filing lawsuits. So it's a complicated challenge for them. And the best answer I can give you is that I mean, other than filing a lawsuit is obviously the most definitive way to address it, but that requires money, it requires effort and time. I think one way that, so one thing that I've tried to do is persuade the state's attorney for the particular county that what their county is doing is not correct, and that they really can't do it that way. But sometimes that works, sometimes it doesn't. Sometimes the county board members just don't listen to their state's attorney, who's the county's lawyer. That has some limitations, that approach. One other approach that I don't know if it's been tried, I mean, one thing that could be done in the interim before we get court decisions is to ask an elected official to seek an opinion from the Attorney General's office. The Attorney General has the authority to interpret state statutes, and they can issue formal opinions when presented with issues. And again, most elected officials, certainly state elected officials, are authorized and entitled to ask the AG's office for opinions. Now, I don't know if the AG's office is going to find that it's a good idea to get in the business of interpreting state siding laws, but it's certainly, that is an avenue that could be pursued.
Yeah, thanks, Peter.
Thanks.
Yeah, all right, thank you, Kyle. Well, we are at 3, but I'll send this around, everybody. Don't forget to put your CLE number in there. But and like I was saying, we've recorded this, and we will send around the materials and slides for review afterward, as well as an evaluation. So thank you so much, Kyle. We really appreciate it. This was a really fantastic presentation.
Yeah, thank you. And thank you for the opportunity to speak and to tell some of my war stories.
Great. All right, thanks. Bye, everybody.